patent attorney here, and in this video we're going to be going over the complicated process of patent prosecution. No, it's not involving crime. It is involving the 4 steps that you must take when you go through and process through a patent application, from beginning to issue to maintenance of the patent. So let's get started. I've got 4 points for you. The first step is to hire an attorney, or you can file it and draft it yourself pro se. That means by yourself. If you go back to one of the other videos, I'll link it below. It describes what specifically is required for your patent application, whether it's provisional or non-provisional. If you file it pro se, you can call the patent office or use one of the appropriate links that are for inventors, and they have a lot of information, a lot of resources. They try to help those inventors who are trying to file the case by themselves, but they are not claiming to represent you, so you're not going to get the best amount of coverage for your intellectual property. So I would highly recommend that you do indeed hire an attorney to draft your patent application. The second step is to file your patent application. You can file it either electronically over the electronic filings system, EFS web, with the patent office, or you can mail it in or hand deliver it to the office in Alexandria, Virginia. Either you or an attorney can file your patent application. The difference being that the patent attorney, when he or she files your patent application, they will be prosecuting your case for you. If you file it on your own, then you won't have an attorney to present persuasive arguments, compelling arguments before the examiner on your behalf. The third step is the examination and prosecution of your patent application. Basically, the examiner will review, do a search, perform a search, and review all of the different prior art references. That includes patent applications and patents that are existing, to see if your innovative concept that you have claimed in your patent application infringes upon any of the prior art. So basically, if there is, they might present a lack of novelty rejection. That's a 102 rejection, or an obviousness rejection. That's a section 103 rejection. Or they might say that your innovative concept really lacks patent eligibility, and that would be a 101, section 101 rejection. There are other rejections like the 112 rejection, which states that your specification lacks enablement, or it lacks a written description that would provide those who are skilled in the art enough information in order to actually replicate your innovative concept. There are other different types of rejections that can be made, but those are the predominant ones. And so what happens during that phase is that your attorney will respond to each office action that the examiner puts forth with those different rejections. So say the examiner states that your invention is not novel because it is included in reference A. And so your patent attorney must refute that rejection if there's a way to show that your specification shows that your innovative concept is more than what is disclosed in A. They lack certain components or elements. And so that goes back and forth between the examiner and the patent attorney. The patent attorney, in order to expedite the process, your patent attorney can ask for an examiner's interview. And during the examiner's interview, typically you can get a meeting of the minds between the examiner and the patent attorney, whereas you can kind of nail down what actually needs to be included or added or modified in the claims, to amend the claims or to amend the specification to take your patent application to issue. And the examination process takes approximately 24 to 36 months. And within 14 to 17 months, you should have your first office action by the examiner. The fourth step is issuance and maintenance of your patent application. There's an agreement that you indeed do have an innovative concept and it doesn't lack novelty, it's not obvious over other references, then your case will be allowed. The examiner will issue a statement that says your patent has been granted. And so it's allowable if you pay the fee in order for it to be issued. I'll link the fee list down below as well. So you have to pay the fee, and that's that. So on the 3.5, 7.5, and 11.5 anniversary, you have to pay a maintenance fee. And this is a time when you can reconsider whether the patent is marketable, if it is valuable for you to continue to keep it maintained out on as a registered patent. And so those fees, and that's in the fee schedule and linked below as well. And so that's it. Those are the 4 steps for the patent examination process. Comprise drafting your patent application, filing your patent application, issuing and paying for the issuance of your patent application into a granted patent, and maintenance of your patent application. Okay, well that's all for now. If you enjoyed this video, give us a like below, subscribe please, and thank you. Have a great day. Bye. If you like this video teaching, please subscribe below and give us a like. Thank you. Also, please note, the material presented herein is for informational, educational, and promotional purposes only. The federal law of the United States is constantly changing. There is no guarantee that all of the relevant changes have been noted herein. As such, this video should not be intended or taken as legal advice. Neither does it establish an attorney-client relationship. Thank you